Hi, it's Guy DiMartino, Northwest Indiana estate planning and probate lawyer. The other day I was meeting with some folks and they had questions about their will and some of the clauses that they could put in their will, and they wanted to know if somebody could challenge the will after they passed away. And the answer is folks can go ahead and do anything. So yes, somebody can go ahead and challenge the will after they pass away, but they have to have a basis for challenging the will. So one basis for challenging the will would be that the person who signed the will, the testator, did not have the legal capacity or mental ability to actually go in and sign the will when they made the will. So they lacked the competence to go ahead and do that, and legally we call that the testamentary capacity. And I said, well, I'm looking at you all right now. You know who the president is, you know what year it is, you know what property you have, and you know what you want to do with your property. You sound like you're pretty competent to me. And one thing that you need to know is that the lawyer who prepares your will, so somebody's going to challenge it, a lot of times they'll become a witness as to the competency of the person who is signing the will. The next way that somebody can challenge a will has to do with this idea of undue influence, that there was somebody that was a fiduciary, somebody that had control over the person who was making the will, and they put coercion on them or they influenced them to go ahead and change their will. And I said, well, we don't have any of that in this situation, and because you all have come in on your own into the office, nobody has brought you. We don't have a kid or a grandkid here saying, you know, leave me everything and write out so and so from the will. So I don't think in this circumstance that we have a problem with undue influence. So you don't have to worry about that. And I said another thing that you can do to shore up your will, if you're concerned that somebody that you're going to leave money to, maybe you're going to be leaving a less of a percentage, or maybe you're going to be writing somebody out of your will that they're going to go ahead and try to contest the will, you can put in a no contest clause. So if you are leaving a sibling or a child a less of percentage than you are some other folks, you can go ahead and put a no contest clause in the will that says, should you contest what you are being left in this will, you will be entitled to nothing. And some courts are upholding these no contest clause as long as they are clear within the writings of the will. So the simple answer to the question is yes. People can challenge or contest a will after the person passes away, but the next question is, will they be successful? And most of the time, unless there's something that egregious that has happened, they will not be successful in contesting your will. If you have any questions about a Northwest Indiana estate planning matter, you can always give me a call. I am Guy DiMartino. Have yourself a great day.